Meadow Chen stood at the edge of what used to be her grandmother's forest, staring at something that shouldn't exist. A massive country club stretched across 10 acres of what was supposed to be untouched woodland, Olympic-sized swimming pool, 6 tennis courts with professional lighting, a 2-story clubhouse with floor-to-ceiling windows that reflected the afternoon sun like a mirror. The air smelled like fresh concrete, chlorine, and money. She'd inherited 12 acres from her grandmother Elena 3 years ago. The front 2 acres held the modest cottage where Meadow had spent childhood summers catching fireflies and learning to bake sourdough bread. The back 10 acres were dense forest, pine and oak trees so thick you couldn't see 20 feet ahead. Meadow had never explored back there, never needed to. She lived in the cottage, worked remotely as a software developer, and paid her property taxes every April without fail. But she hadn't walked the full property line in 3 years. Too busy, too tired, too consumed with deadlines and video calls and the general chaos of life after 35. Now she understood why the construction noise had been so loud for the past 18 months. The chainsaws, the cement mixers. The sound of machinery that she'd assumed was coming from the new subdivision a mile away. It hadn't been a mile away. It had been in her backyard. A woman in white tennis shorts and a visor approached from the clubhouse, racket in hand. She was about 50, with the kind of tan that comes from having time to lie by pools, and the kind of confidence that comes from never being told no. The woman stopped 10 feet away, looking Meadow up and down with the expression of someone who'd found a stray dog on her lawn. Meadow was wearing paint-stained jeans and an oversized flannel shirt, her blonde hair pulled back in a messy ponytail. She probably looked exactly like what she was, someone who'd just discovered something impossible on their property. The woman planted her racket on the ground like a walking stick. She introduced herself as Vivienne Ashford, president of the Riverside Heights Homeowners Association. Her voice had that particular smoothness that came from years of getting exactly what she wanted. Vivienne explained, as if speaking to a child, that this was the Riverside Heights Elite Country Club. 16 months of construction, $4 million in development costs. Membership was exclusive to the 400 homeowners in Riverside Heights, each of whom had paid $10,000 for lifetime access. The grand opening party had been last weekend. Champagne fountain, live jazz band. The mayor had cut the ribbon. Meadow interrupted quietly. This was her property, all of it, 12 acres inherited from her grandmother. Vivienne's smile didn't waver, but something cold flickered behind her eyes. She pulled out her phone with manicured nails painted the color of fresh blood. She scrolled, then showed Meadow a document. "County records," she said. This land was listed as abandoned woodland, unclaimed, perfect for community development. The HOA had filed all the proper permits. Everything was legal. Everything was approved. Meadow felt her stomach drop. She'd been paying taxes on this land for 3 years. "How could it be listed as abandoned?" Vivienne continued, her voice dripping with false sympathy. If Meadow was confused about property boundaries, she could recommend a good surveyor, but this club wasn't going anywhere. 400 families depended on it. Children took swimming lessons here. Seniors played morning tennis. This was about community, about bringing people together. Then Vivienne's voice changed, lost the sugar coating. She suggested that if Meadow tried to cause problems, tried to claim what wasn't hers, there would be consequences. Legal fees, harassment charges. The Riverside Heights HOA had very good attorneys, very expensive attorneys. Did Meadow have that kind of money? Could she afford a years-long legal battle? Meadow looked past Vivienne at the country club. Families were arriving for afternoon swim sessions, kids in colorful swimsuits, parents carrying towels and sunscreen. A teenager was practicing serves on the tennis court, the rhythmic thwack of ball against racket echoing across the manicured lawn. Something inside Meadow went very quiet and very cold. She thought about her grandmother Elena, who'd bought this land in 1968 with money saved from working 3 jobs, who'd paid cash and kept every receipt in a fireproof box, who'd told Meadow on her deathbed, "Don't let anyone take what's yours, not ever." Meadow had that fireproof box. She had grandmother's original deed. She had 3 years of property tax receipts. She had survey maps that showed every inch of these 12 acres. But standing there, looking at Vivienne's smug face and the $4 million country club built on stolen land, Meadow made a decision. She wouldn't say anything, not yet. She thanked Vivienne for the information, said she must have been confused about the property line, apologized for the misunderstanding, watched Vivienne's face relax into victory. Vivienne patted her arm, the gesture condescending and final. She was glad they could clear this up without drama. The club was having a member appreciation barbecue next month. Maybe Meadow could attend as a guest, see what the community had built, understand why this was bigger than one person's confusion. Meadow walked back to her cottage, her heart pounding. She went straight to the closet, pulled down the fireproof box, and spread its contents across her kitchen table. Deed, survey maps, tax receipts. Grandmother's handwritten notes about property boundaries, complete with hand-drawn diagrams and measurements. She pulled out her laptop and started documenting everything, took 300 photos of the country club from every angle, downloaded satellite imagery showing the construction timeline, requested copies of all HOA permits from the county, filed a public records request for the abandoned land designation that Vivienne had mentioned. Then Meadow did something that would seem insane to most people. She decided to wait. Let them enjoy their country club. Let them host pool parties and tennis tournaments. Let every one of those 400 families pay their $10,000 and believe they owned access to this facility. Because when the truth came out, when she finally pulled that deed out in court, the explosion would be so much bigger. Over the next 6 months, Meadow became invisible. She watched the Riverside Heights Elite Country Club operate like a well-oiled machine from her cottage window. She documented everything with the methodical precision of someone who'd spent 15 years writing code, breaking down complex problems into manageable data points. She started with the paper trail. The county records showed that Vivienne's HOA had filed for a community development permit in March 2 years ago. The application listed the land as unincorporated county woodland, abandoned, no active ownership. But that was impossible. Meadow had been paying property taxes the entire time. She pulled her bank statements, matched every payment to county records, not a single missed payment, not even a late payment. She filed a Freedom of Information request and discovered something stunning. The HOA's permit application had included a title search conducted by a company called Prestige Title Services. The search claimed no active ownership could be found, but Meadow's grandmother's deed was recorded in 1968, clear as day, in the county recorder's office. She drove there personally, requested the physical document, and photographed every page. Someone had lied. Either Prestige Title Services had done the world's worst title search, or they deliberately omitted her ownership to smooth the permit process. Meadow hired a private surveyor named Marcus Webb, a semi-retired engineer who'd been surveying Colorado properties for 40 years. She paid him $2,000 to conduct a complete boundary survey of her 12 acres. Marcus spent 3 days walking the property with GPS equipment, comparing her grandmother's 1968 survey to current satellite imagery. His report was unambiguous. The country club was built entirely on Meadow's property, not partially, not along a disputed boundary line. 100% of the facility sat on her land. The pool, the tennis courts, the clubhouse, even the parking lot. All of it. Marcus had asked her the obvious question. Why wasn't she screaming from the rooftops? Why wasn't she calling lawyers and news stations? Meadow had smiled and said she wanted to be absolutely certain first, make sure every detail was bulletproof. Marcus had nodded, professional enough not to push, but she could see the curiosity in his eyes. The truth was, simpler and more calculated, she wanted them to invest more. Vivienne's HOA had spent $4 million building the facility, but operation costs were adding up. She watched as they hired lifeguards, tennis instructors, maintenance crews. They installed a new sound system for outdoor movies. They built a playground for member children. Every month, they poured more money into a property they didn't own. Meadow created a spreadsheet tracking every expense she could identify. Lifeguard salaries, $8,000 per month. Maintenance, $12,000 per month. Utilities, $6,000 per month. Insurance, $15,000 per month. The ongoing costs were staggering. She also tracked membership. All 400 Riverside Heights families had paid their $10,000 lifetime membership fee, $4 million collected. But Vivienne was clever. She'd structured it as a homeowner benefit tied to property ownership. If you sold your house in Riverside Heights, the club membership transferred to the new owner. It increased property values. Houses in Riverside Heights were selling for $30,000 more than comparable homes in neighboring subdivisions, specifically because of club access. Meadow documented the marketing materials, glossy brochures showing families laughing by the pool, testimonials from members about the best decision we ever made, social media posts with hashtags like Riverside Life and Exclusive Living. Vivienne had built an empire on stolen land, and she was profiting magnificently. But Meadow also documented something else, the harassment. It started subtle. Vivienne began hosting HOA events at the club on weekend afternoons, barbecues, movie nights, wine tastings. The noise carried across the forest to Meadow's cottage, music thumping until midnight, car headlights sweeping across her windows as members left. Then it escalated. Someone started parking cars on the dirt road leading to Meadow's cottage, blocking her access. She'd come home from grocery shopping to find 3 SUVs completely blocking the path. She'd have to knock on doors at the clubhouse, ask whose vehicles they were, endure eye rolls and sighs as members slowly, reluctantly moved their cars. Vivienne appeared at her door one evening in October. She brought a plate of cookies, her smile bright and fake as plastic flowers. She explained that some members had complained about Meadow's cottage being visible from the tennis courts. It was a bit of an eyesore, wasn't it? Would Meadow consider selling? The HOA would offer fair market value, maybe even a bit extra as a gesture of goodwill. Meadow had taken the cookies, thanked Vivienne politely, and said she wasn't interested in selling. This was her home. Vivienne's smile had frozen. She'd made some comment about property values, about fitting into a community, about the greater good. Then she'd left, and the cookies had gone straight into the trash. Meadow didn't trust anything that woman touched. A week later, Meadow received a certified letter from an attorney named Preston Blackwell of Blackwell & Associates. The letter was 3 pages of dense legal language that boiled down to a simple threat. Meadow's cottage was allegedly violating multiple county codes, unpermitted structures, potential sewage issues, fire hazards. If she didn't allow a county inspection within 30 days, legal action would follow. Meadow called the county the next morning, spoke to a tired-sounding inspector named Tom Reeves. He'd never filed any complaint about her property, never even heard of her address. When she read him Preston Blackwell's letter, Tom went silent for a long moment. Then he'd said something that made Meadow's blood run cold. Preston Blackwell's firm represented the Riverside Heights HOA. Tom had seen them pull this tactic before. Manufacture code violations, pressure property owners, make life difficult until they sold. It was legal harassment disguised as community concern. Meadow thanked Tom and hung up. She added Preston Blackwell's letter to her growing file of evidence: harassment, intimidation, fraud. The trap was building itself by December. Vivienne Ashford had decided Meadow Chen wasn't just a nuisance. She was a threat that needed to be eliminated. It started with the fence. Meadow woke up one Monday morning to find construction crews building an 8-foot privacy fence along what Vivienne claimed was the property boundary between the club and Meadow's cottage. The fence was going up fast, prefabricated panels installed with industrial efficiency. Meadow walked out in her bathrobe to find the foreman, a weathered man named Carl, who looked deeply uncomfortable. She asked who authorized construction on her property. Carl showed her a work order from the HOA, signed by Vivienne with a surveyor's map attached. The map was wrong. Completely, deliberately wrong. It showed the boundary line running 50 feet into Meadow's actual property, effectively cutting off her cottage from the back forest. When Meadow pointed this out, Carl had shrugged apologetically. He was just following the work order. If there was a property dispute, she'd need to take it up with whoever hired him. Meadow called Marcus Webb, her surveyor. He arrived within an hour, took one look at the fence location, and shook his head. This was at least 40 feet onto her property, maybe more. He could file an emergency survey, but that would take days to process through the county. By then, the fence would be finished. Meadow made a decision. She let them build it. Watched the fence go up, panel by panel, enclosing her cottage in an ever-shrinking space. She took photos of every stage, documented the workers, the equipment, the HOA work orders taped to the foreman's clipboard. When Carl and his crew finished 3 days later, Meadow's cottage was boxed in. The new fence blocked her view of the forest, blocked afternoon sunlight, made her feel like a prisoner in her own home. But she said nothing, just smiled and waved at Carl as he packed up his tools. That weekend, Vivienne hosted a holiday party at the club. Meadow could hear music and laughter through the fence. She sat in her darkened cottage, adding the fence construction costs to her spreadsheet, another $60,000 spent on her property without permission. The harassment intensified. Someone began filing anonymous complaints with the county. Meadow's cottage was a fire hazard. Her septic system was failing. She was running an illegal business from her home. Each complaint triggered an inspection, and each inspector found nothing wrong. But the inspections were disruptive, stressful, time-consuming. Tom Reeves, the county inspector, pulled her aside after the fourth false complaint. Off the record, he said, someone was trying to bury her in bureaucracy. He'd seen this pattern before with aggressive HOAs. They couldn't force her out legally, so they'd make her life miserable until she left voluntarily. In January, Vivienne made her boldest move yet. She filed a lawsuit against Meadow for trespassing. The legal filing claimed Meadow had repeatedly entered HOA property without permission, harassed club members, and created a hostile environment. It included sworn statements from 3 members who claimed they'd seen Meadow lurking near the tennis courts and taking photos of children at the pool. Every word was a lie. Meadow had never set foot on the club grounds. The photos existed, yes, but they'd been taken from her own property with a telephoto lens, documenting the facility for her eventual legal case. Preston Blackwell, Vivienne's attorney, demanded Meadow stay at least 200 feet away from all club facilities. Given the fence placement that would effectively confine her to her cottage, she'd be trapped in a 100-square-foot area, unable to access most of her own property. The hearing was scheduled for February 15th. Meadow had exactly 6 weeks to respond. She spent those weeks building her case with obsessive precision. She hired an attorney named Lydia Morse, a property rights specialist in Denver who'd made her reputation destroying predatory HOAs. Lydia's consultation fee was $500. Meadow paid it with money she'd been saving for a kitchen renovation. Lydia listened to the entire story without interrupting. When Meadow finished, spreading out her documentation across Lydia's conference table, the attorney sat back with an expression Meadow couldn't quite read. Then Lydia started laughing. Not polite laughter, but genuine, delighted cackling. She picked up Grandmother Elena's deed, Marcus Webb's survey, the photographs of fence construction, and the lawsuit for trespassing. This was the most beautiful thing Lydia had seen in 20 years of property law. Vivienne Ashford had built a $4 million country club on stolen land, spent another $1 million in operating costs, collected $4 million from unsuspecting members, and was now suing the actual property owner for trespassing on her own land. It was like watching someone rob a bank, then sue the bank for not having better security. The audacity was breathtaking. Lydia explained the strategy. They wouldn't reveal Meadow's ownership yet. They'd let the trespassing lawsuit proceed. Let Vivienne present her case. Let her commit to her lies under oath. Let her bring member witnesses who'd swear they saw Meadow trespassing. Then in court they'd drop the evidence like a nuclear bomb. The deed, the survey, the tax receipts. Proof that every square inch of the country club sat on Meadow's private property. Proof that Vivienne had known, or should have known, through basic due diligence. Meadow asked the obvious question. What if they lost? What if somehow, impossibly, the judge sided with Vivienne? Lydia's smile was sharp enough to cut glass. They wouldn't lose. This case was what lawyers called a slam dunk. But even if they did, Meadow would lose nothing she didn't already have. Her property was already occupied, the fence was already built. The harassment was already happening, but if they won, and they would, Meadow would own a $4 million country club. She could demand the HOA tear it down and restore her forest, or she could negotiate a settlement for millions in damages, or she could do something else entirely, something that would make this whole nightmare worthwhile. Lydia quoted her retainer fee, $40,000 upfront with additional costs billed monthly. When they won, the court would order Vivienne's HOA to pay all legal fees. Meadow had $17,000 in savings. She liquidated her retirement account, took a penalty hit, and paid Lydia in full. Then she went home to her fenced-in cottage and waited for February 15th. The Boulder County Courthouse smelled like floor polish and tension on February 15th. Meadow arrived at 8:30 in the morning, wearing a simple navy dress and minimal makeup. She'd tied her blonde hair back in a professional bun. Lydia had coached her. Look respectful. Look like someone who respects the legal system and expects the legal system to respect her back. Vivienne Ashford arrived at 8:45 in a cream-colored designer suit that probably cost more than Meadow's car. She was flanked by Preston Blackwell and two associates carrying leather briefcases thick enough to stop bullets. Vivienne saw Meadow in the hallway and smiled, the kind of smile a cat gives a mouse before the final pounce. The courtroom was smaller than Meadow expected. Judge Catherine Monroe presided, a woman in her early 60s with steel gray hair and reading glasses on a chain. She had the no-nonsense energy of someone who'd seen every legal trick in the book and wasn't impressed by any of them. Preston Blackwell presented the HOA's case first. His voice was smooth, practiced, theatrical. He painted Meadow as a troubled individual who'd become obsessed with the country club, who took invasive photographs of families who repeatedly trespassed despite warnings, who created an atmosphere of fear among peaceful community members. He called 3 witnesses. First was a woman named Stephanie Grant, mother of 2, who testified that she'd seen Meadow watching children at the pool through the fence. It made her uncomfortable, made her question the club's safety. Second was a man named Richard Torres, tennis enthusiast, who claimed Meadow had confronted him in the parking lot, demanding to know who authorized construction on her property. He'd felt threatened. Third was Vivienne herself. She took the stand wearing an expression of concerned civic duty. She testified that the HOA had tried repeatedly to address Meadow's concerns through proper channels. They'd offered to buy her cottage at above market value. They'd attempted mediation, but Meadow refused all reasonable solutions. Now, for the safety of 400 families, they needed a restraining order. Judge Monroe listened impassively, making occasional notes. When Preston Blackwell finished, she turned to Lydia Morse. The attorney stood, smoothed her jacket, and dropped the first bomb. She asked for permission to introduce new evidence, counter-evidence that would make the HOA's entire lawsuit irrelevant. Judge Monroe raised an eyebrow but nodded. Lydia walked to the evidence table and picked up a document sealed in plastic. She held it up like a holy relic. This was the original deed for 12 acres of land, recorded in Boulder County on March 14, 1968, in the name of Elena Chen. Upon Elena's death in 2020, the property transferred to her granddaughter, Meadow Chen. She handed certified copies to the judge and to Preston Blackwell. Meadow watched the attorney's face drain of color as he read. Lydia continued, her voice cutting through the courtroom like a blade. The property in question, all 12 acres, belonged entirely to Meadow Chen. She'd been paying property taxes without interruption since inheriting. She had 3 years of receipts, all entered into evidence. Then Lydia presented Marcus Webb's survey. The professional surveyor had confirmed that 100% of the Riverside Heights Elite Country Club sat on Meadow's private property. Not partially, entirely. Every pool, every tennis court, every square foot of the clubhouse. The courtroom went absolutely silent. Judge Monroe leaned forward, studying the documents. Preston Blackwell was flipping through pages, his smooth courtroom demeanor cracking like ice on a thawing lake. Vivienne Ashford had gone pale as chalk. Lydia wasn't finished. She presented the HOA's permit application, the one that claimed the land was abandoned. She presented Prestige Title Services' fraudulent title search. She presented photographs documenting the fence built 50 feet onto Meadow's property. She presented the anonymous code complaints, the harassment, the attempt to force a sale. Then came the financial evidence. Lydia had obtained, through legal discovery, the HOA's complete financial records. $4 million collected from member fees, another $1 million spent on operations, $30,000 increases in Riverside Heights property values marketed explicitly on club access. Judge Monroe interrupted. She looked at Preston Blackwell. Did your client conduct any title search before beginning construction? Any due diligence whatsoever? Preston started to speak, stopped, started again. Your Honor, we relied on Prestige Title Services, a licensed title company. They assured us the land was available for development. The judge turned to Lydia. Do you have evidence suggesting the title company knowingly falsified their search? Lydia smiled. She did. Prestige Title Services was owned by Vivienne Ashford's brother-in-law, Grant Ashford. She presented corporate filings, family tree documentation, and an email chain between Vivienne and Grant discussing expediting the title process for the club project. The judge removed her reading glasses and cleaned them slowly, methodically. This was a gesture Meadow would later learn meant Judge Monroe was profoundly angry and working to maintain judicial composure. When she spoke, her voice was ice. This court finds that the Riverside Heights Homeowners Association has committed knowing and willful trespass on private property. The HOA filed a fraudulent title search, built a commercial facility without property owner consent, and is now attempting to legally bar the actual property owner from her own land. She looked at Vivienne Ashford. The restraining order is denied. In fact, I'm issuing a temporary restraining order against the HOA. All club operations will cease immediately pending resolution of property rights. Vivienne stood up, her composure finally shattering. Your Honor, we have 400 families who depend on this facility, children who take swimming lessons, seniors who play tennis. You can't just shut it down. Judge Monroe's expression could have frozen nitrogen. I can, and I am. This court will reconvene in 30 days for a full hearing on damages and restitution. Until then, the club is closed. She struck her gavel. The sound echoed like a gunshot. The 30 days between court sessions felt like watching dominoes fall in slow motion. Each piece of Vivienne Ashford's empire collapsed with mathematical precision. First came the member revolt. Within hours of Judge Monroe's ruling, the Riverside Heights community Facebook group exploded with over 2,000 comments. 400 families had paid $10,000 each for country club access that was now legally invalid. The pool was drained, the tennis courts were locked, the clubhouse sat empty, its floor-to-ceiling windows reflecting nothing but sky and trees. Parents who'd enrolled children in swim lessons demanded refunds. Seniors who'd played morning tennis for 18 months felt betrayed. Property owners who'd bought homes specifically for club access saw their $30,000 premium evaporate overnight. Houses that had sold for $500,000 were now worth $470,000 at best. The HOA emergency meeting on February 20th was, by all accounts, absolute chaos. Meadow didn't attend, but she received a detailed summary from Marcus Webb, whose sister lived in Riverside Heights. Over 300 homeowners packed into the community center, screaming at Vivienne Ashford. Where was their money? Why hadn't proper title searches been done? Who was responsible? Vivienne tried to deflect. Blamed Prestige Title Services. Blamed the county for approving permits. Blamed Meadow for not clearly marking her property boundaries. But the crowd wasn't buying it. These were people who'd saved for years to afford Riverside Heights, who'd believed in the American dream of exclusive community living, and now that dream was drowning in lawsuits and fraud charges. The HOA board voted unanimously to remove Vivienne as president. She was escorted from the building by private security while 300 people watched in silence. Second came the criminal investigation. Judge Monroe had referred the case to the district attorney's office for fraud charges. Investigators seized records from both the HOA and Prestige Title Services. Within a week, the pattern became clear. This wasn't Vivienne's first time. Over the previous 12 years, she'd been involved in 4 similar developments across Colorado. The strategy was always the same: find land with unclear or elderly ownership, file aggressive claims, build quickly, profit massively. In 3 previous cases, the original owners had been too poor, too old, or too frightened to fight. They'd settled for pennies on the dollar, and Vivienne had walked away rich. But Meadow Chen had receipts. More importantly, she documented everything with the systematic precision of a software developer who understood that data never lies. The district attorney filed 6 felony fraud charges against Vivienne and 3 against her brother-in-law, Grant Ashford. Both faced up to 15 years in prison if convicted.
Third came the financial unraveling. The HOA had spent over $5 million building and operating a facility they'd never legally owned. Their insurance refused to cover claims, citing fraud exclusions. The 400-member families filed a class-action lawsuit seeking return of their $10,000 fees plus damages for property value loss. Vivienne's personal assets were frozen pending litigation. Her house in Riverside Heights, her vacation condo in Vail, her Range Rover, her investment accounts, all locked down by court order. Preston Blackwell, the attorney who'd filed the trespassing lawsuit, was censured by the Colorado Bar Association for failure to conduct basic due diligence. He resigned from his firm before they could fire him. But the question everyone asked was, what would Meadow Chen do now? The country club sat on her property. Legally, she could demand the HOA demolish it completely, restore her 10 acres to forest, and pay millions in damages. Several attorneys reached out, offering to maximize her settlement. She could walk away with $8, maybe $10 million. Meadow thought about it for exactly 3 days. Then she made a series of phone calls that surprised everyone. First, she called Tom Reeves, the county inspector who'd warned her about the harassment campaign. She asked for his help organizing a community meeting. Tom, intrigued, agreed. Second, she called Lydia Morse, told her attorney about an idea that was either brilliant or insane. Lydia listened, laughed, and said it was definitely brilliant. Third, she printed 400 letters, one for every household in Riverside Heights. The community meeting was held on March 10th at the same community center where Vivienne had been ousted. Meadow arrived early, nervous, wearing jeans and a purple sweater that had been her grandmother's favorite color. Her blonde hair was loose around her shoulders. She looked like exactly what she was. A 35-year-old software developer who'd never asked for any of this. Over 300 people showed up. The room was tense, expectant. These families had paid for something they'd lost. They were victims, same as Meadow. She stood at the front of the room, no podium, no formal presentation. Just her and a microphone, and the truth. She introduced herself, told them about grandmother Elena, who'd bought this land with money saved from 3 jobs, who'd taught Meadow about justice and fairness and standing up for what's right, who'd left her 12 acres and a note that said, "Don't let anyone take what's yours." Then Meadow explained what she was offering. She would donate the country club property, all 10 acres, to a nonprofit community trust. The trust would be governed by elected representatives from Riverside Heights. All 400 families would have equal ownership through the trust. No fees, no memberships, no exclusivity. The Bus Club would remain operational, maintained through modest monthly dues determined by the community. Any homeowner who'd lost property value due to the fraud would receive partial reimbursement from the eventual settlement with Vivienne and Prestige Title Services. But there was one condition. The trust would rename the facility the Elena Chen Community Center, and 20% of monthly operating surpluses would fund college scholarships for low-income Colorado students studying engineering, computer science, or property law. The room was silent. Then someone in the back started clapping. Then another. Within seconds, 300 people were on their feet, applauding, some crying, some laughing in disbelief. Sarah Martinez, a teacher who'd bought her first home in Riverside Heights, approached afterward with tears streaming down her face. She'd thought she'd lost everything. Instead, she'd gained something better, a real community, one built on fairness instead of exclusivity. Judge Monroe approved the settlement on March 28th. Vivienne Ashford pleaded guilty to fraud charges and was sentenced to 4 years in federal prison. Grant Ashford received 3 years. Preston Blackwell was disbarred. The HOA's insurance eventually paid out $2.3 million to the community trust. Member families received average refunds of $4,500 each. Riverside Heights property values stabilized not at their inflated peak, but at honest, sustainable levels. Meadow kept her cottage and the front 2 acres, just like always. The fence was torn down, replaced with a simple walking path connecting her home to the community center. On warm evenings, she'd walk over and watch families swimming, children playing, neighbors becoming actual neighbors. The Elena Chen Memorial Scholarship awarded its first grant in September, $10,000 to a young woman from Denver studying civil engineering. The girl's essay had been about property rights, justice, and standing up to bullies who think money makes them untouchable. Meadow framed that essay and hung it in her cottage right next to grandmother Elena's original deed, because sometimes justice isn't about revenge or profit. Sometimes it's about taking something built on theft and lies and transforming it into something honest, something good, something that honors the people who came before and protects the people who come after. Vivienne Ashford had tried to steal 12 acres. Instead, she'd accidentally created a community. And that, Meadow thought, was the most perfect trap of all,